What is contributor negligence? In every tort, tort is a civil wrong. That wrong is caused due to this malfeasance, misfeasance, and nonfeasance. Malfeasance means doing an unlawful act, tort will arise. Misfeasance, doing a lawful act in an improper manner, there will be a tortious liability. Nonfeasance, there is omission to do a particular act. So here, when there is a negligence means sometimes due to negligence of a person, he commits a tort. Negligent failure of duty to take care. While doing a lawful act, a person fails to take care in performing that act with due care and attention. In such case, if any damage is caused to another by such act, he is liable under the law of tort. So negligence, in every negligence, there is a failure of duty to take care. We have already discussed. The leading case in the matter is Danube versus Stevenson. Then that is famous ginger beer case. And the second case is Australia knitting mill versus Grant. And there are other cases of it. Those are the milestones in this negligence. So contributor negligence means what? What is contributor negligence? Suppose because of negligence of a defendant, a tort is committed, but in that tort, the plaintiff has contributed some amount of negligence. So in such case, then plaintiff will be treated, then that is a good defense in tort. That is contributor negligence. Plaintiff has contributed to the negligence because the tort was not committed only due to negligence of the plaintiff, the defendant, but the plaintiff was also responsible and had contributed some negligence to it. So that is called contributor negligence. But what is contributor negligence? When the plaintiff, what is contributor negligence? The plaintiff by his own want of care contributes to the damage caused by the negligence of the defendant because of his own want of care, because plaintiff's own want of, due to his own want of care, he contributes to the damage caused by the negligence or wrongful conduct of the defendant. He is considered to be guilty of contributor negligence. That the defendant is negligent, but the plaintiff has also contributed some extent of negligence because of his want of care, of his own want of care. That is called contributor negligence. Suppose an accident resulted, there may be contributor negligence in an accident. When, if the proximate cause of the accident, immediate cause of the accident is the act of omission amounting to what of ordinary care or in defiance of duty or obligation on the part of the complaining party, that is the plaintiff, then the other party, then that's conjoined with the other party negligence, that will be treated as contributor negligence. Suppose here X is driving a motorbike on a road. The plaintiff, without taking any care, crossed the road in front of him. Thereafter, there was an accident, he died. So who will be responsible for that? Defendant, negligent, is there causing death. But here, plaintiff himself has contributed. Because of his own want of care, there was damage. And that damage was caused, it was to in that accident to another. What is that? In Municipal Corporation Greater Bombay versus Lakshman Iyer, the Honorable Supreme Court has observed, where an accident is to negligence of both parties, substantially there would be contributor negligence and both would be blamed. That when an accident takes place due to negligence of both the parties, both of the plaintiff as well as the defendant, so both have to blame. In a case of contributor negligence, what is to be? The crucial question on which liability depends would be whether either party could, by exercise of reasonable care, have avoided the consequence. When the question of contributor negligence comes, then to give damages or before giving compensation, the court to adjudicate whether who is to be blamed for the accident. That means whether with an ordinary care of a particular person, the accident would have been avoided, consequence of other negligence. Whichever party could have avoided the consequence of other negligence would be liable for the accident. If the plaintiff himself would have avoided the accident had he taken a ordinary care, then he is to blame. So he cannot realize compensation from the defendant. This is a good defense. If a person's negligence act or omission was the proximate cause of death, the fact that the person suffering injury was himself negligent and also contributed to the accident or other circumstances by the injury was caused would not afford a defense to the other. Particularly in death cases, when because of negligent act or omission was the immediate cause of death, the fact that the person suffering injury was himself negligent, if a immediate cause, somebody's act caused death, the other party was negligent, that will not, in such case, in death cases, that defense cannot be. Contributor negligence is applicable solely to the conduct of the plaintiff. Solely to the conduct of the plaintiff. That is, thus, this is a defense in which the defendant has to prove that the plaintiff failed to take reasonable care for his own safety. And that was a contributing factor to the harm ultimately suffered by the plaintiff. The plaintiff himself had taken did not take reasonable care because of he ultimately suffered. That is, the harm ultimately suffered by the plaintiff. If A going on the wrong side of the road is hit by a vehicle coming from the opposite direction and driven rashly by B, A can be met with an defense of contributor negligence on his part. So if A going on the wrong side of the road is hit by a vehicle coming from the opposite direction and driven rashly by B, A can be met with the defense of contributor negligence. In such case, the B may take the defense of contributor negligence. So contributor negligence, when there is a contributor negligence, then that is a good defense. In rural transport service versus Bezlum BB, in this case what happened? The driver of a omnibus invited some passengers. The passengers, they sat on the top roof of the bus, and while the driver driving the bus, while overtaking another bus, took it to the side of the road, and ultimately, because of that taking of the bus to the side of the road, one branch hit the head of one of the passengers who was sitting on the roof of the bus, and he died. So here the death, it was held that both the driver and the conductor were negligent towards the passenger who were invited to sit on the roof. There was also contributor negligence on the part of the passengers, including the deceased, who took the risk of traveling on the roof of the bus. In such case, the compensation will be less. The Davies versus Swan Motor Co. Ltd., an employee of a Swansea Corporation, in contravention of the regulatories, was riding on the stakes attached to the offside of the dust lorry, where another vehicle was overtaking that lorry. Consequently, the employee standing on the steps of the lorry was hit, seriously injured, and ultimately died. It was held that although there was negligence on the part of the driver of the omnibus, there was also contributor negligence on the part of the deceased. Contributor negligence on the part of the deceased. Similarly, Wagendar Paul Chaudhary versus Durgadas, the Delhi High Court held that a pedestrian who tries to cross a road all of a sudden and is hit by a moving vehicle without taking care, all of a sudden pass the road, and he met with an accident, he is guilty of contributor negligence. Similar decision was also there in Nance versus British Columbia Electric Railway Company. In the case, the deceased crossed the road which had become slippery due to ice. As he suddenly came in front of the motor vehicle, he was run over by the shed. It was held that there was contributory negligence on the part of the deceased. In Harris versus Toronto Transit Commission case, what the Supreme Court of Canada held that if a boy sitting in a bus projected his arm outside the bus, in spite of warning and is injured, he is guilty of contributory negligence. Contributory negligence is a good defense. To be guilty of contributory negligence, the plaintiff should not have acted like a prudent man. So, plaintiff has contributed negligence. So, the defendant must prove that the plaintiff did not act as a prudent man. Thereby, he suffered damage. If he has taken as much care as prudent man, as much care as a ordinary man who have taken in this situation, there is no contribution. In Sushma Mitra versus Madhya Pradesh State Road Transport, the plaintiff was traveling in a bus, resting her elbow on a window sill. So the bus at that time was moving on a highway. When highway, the bus was moving, so the passenger had rested his elbow on the window sill. She was injured when hit by a truck which was coming from the opposite direction. When sued for the injury, it was the defendant took the plea that the act of resting elbow on the window sill was a contributory negligence. The Madhya Pradesh High Court did not allow this defense. Why? Because the bus was passing, running on the highway. In the highway, ordinarily people rest the elbow on the window. It was not in a busy locality. The bus was not moving inside a busy locality, inside a town. It was held that as she acted like a reasonable passenger. A reasonable passenger never expects there will be danger to his elbow while resting on his elbow on the window sill on highway. She rested. She put her elbow. So it was observed. What they in that case Madhya Pradesh High Court observed? It is clear that the plaintiff cannot be held to be guilty of contributory negligence in this circumstance. It is true that in crowded street of big towns, the passengers who are adults are expected to keep their limbs within the carriage. It was not in a crowded place. It is only in a crowded place in a big town. The passengers were expected to keep their body fully inside the bus. If they fail to take these safety measures, but then there will be contributory negligence. But here in this case, the plaintiff was injured while the bus was moving on a highway outside the limits of the town. So in such a case, even a man of ordinary prudence would rest his elbow on the window sill while the bus was running on the highway. Similarly, in Mr. Sydney Victor versus Janab, in this case, Mr. Victor, who was traveling in a bus, was holding a window crossbar of the bus while her right thumb was gripping the window bar on its outer side. The lorry coming from the opposite direction was being driven negligently. The sides of the two vehicles hit each other. As a result, the thumb of Mistress Victor was completely severed, and another passenger, Mr. Chandra, received head injury. The plea of the defendants that gripping of the bar with the thumb outside was contributory negligence. That was pleaded by the defendant. Here, the Madras High Court, that is, Mr. Victor was rejected by this. Negligence on the part of Mr. Victor was rejected by Madras High Court. It was held that mere gripping on the window crossbar in a position in which the right thumb was gripping the bar on its outside would not be negligent act on the part of the injured plaintiff, especially when the vehicle was on a broad highway and not moving on a crowded place. In another case, Klasu Mitla Bachet versus East India Hotel India, the plaintiff, a co-pilot, in this case of Lufthansa Airlines, checked into hotel and Oberoi International, a five-star hotel in Delhi on 11th August 1972. As he dived from the diving board in the swimming pool on 13th August 1972, he hit by bottom of the pool due to insufficient of water in the swimming pool. So here and got seriously injured, resulting in paralysis and died 13 years after the accident. The pool was considered to be a trap and the hotel premises were considered to be hazardous, for which the defendants running the said hotel were held liable. there was held to be no contributor negligence because in a swimming pool, he jumped into the swimming pool, his head hit the top bottom because of want of sufficient water. So there is no, you cannot say that the plaintiff was, that the dishes are contributor negligence. Similarly, the decision of the Punjab and Haryana High Court in Pepsu Road Transport Corporation, but Kuimat Rai Jain is also there, the same effect. In the case, what? While two passengers were resting their elbows on the windowsill of the bus, a truck coming from the opposite direction grazed against the right side of the bus, resulting in injuries to the passengers. The result to be composite negligence. On the composite negligence, what? Both bus vehicles are negligent. That is composite negligence. We'll discuss on the part of the drivers of the bus in which they were traveling, and but no contributor negligence. It was observed that no contributor negligence on the part of the claimants. It was observed that the driver of a bus, while overtaking or crossing another vehicle, must keep in mind the normal tendency of a passenger sitting near the window to have his arm resting on it, and may even be protruding a little, and he must therefore take care to leave sufficient space from the between his vehicle and the bus. So when the plaintiff is negligent, but his negligence has not contributed to the support, there may be negligence, but that. So here, the defense of contributor negligence cannot be pleaded. In Municipal Board versus Jaunpur versus Brahmkishore, the plaintiff who was going on his cycle without headlight on a road in the darkness fell into the ditch dug by the municipal corporation. That is because of darkness. It was held that the accident could not have been avoided even if the cyclist had fixed kerosene lamp and in the front of his cycle. If the cyclist had used any torchlight or kerosene lamp, you could not have avoided that, which is generally used by the cyclist, and therefore there was no contributor negligence. So even in Agya Kaur versus Pepsu Road Transport Corporation, a rickshaw which was being driven on the correct side of the road was hit by a bus coming on the wrong side of the road at a high speed. Here, the bus did not stop after hitting the rickshaw, but thereafter hit an electric pole on the wrong side. The rickshaw puller at the time was carrying 3 adults and a child in the rickshaw. It was held that although the rickshaw was overloaded, the contributor negligence was pleaded because the rickshaw was overloaded, but the factor did not contribute to the consequence because the rickshaw puller was carrying 3 passengers. That was not the factor which was the cause of this accident, approximate cause of the accident. The accident was held to be due to the negligence on the part of the defendants only, that is driver of the bus. So, and there was held to be no contributor negligence. Even if the rickshaw was without a passenger also, or with 1 or 2 passengers, the accident would not have been avoided. So in such case, and therefore, the mere fact that the deceased rickshaw puller was carrying 3 adults and a child would be no ground to make a deduction in the award of compensation on the ground of contributor. How far is contributor negligence a defense? At common law, contributor negligence on the part of the plaintiff was considered to be a good defense, and the plaintiff lost his action, common law courts. But the plaintiff's own negligence licenses him to bring any action against the negligent defendant. Here, plaintiff's negligence does not mean breach of duty toward the other party, but it means absence of due care on his part about his own safety. The rule of law is that if there is a blame causing the accident on both sides, however small, that blame may be on the one side. The loss lies when it fails. In Butterfield versus Forster, the defendant wrongfully obstructed a highway. In this case, Butterfield and Forrester. In this case, the defendant wrongfully obstructed a highway by putting a pole across. The highway was obstructed by putting a pole. Defendant had putting up obstructed highway. The plaintiff was riding violent in the twilight on the road, collided against the pole and was thrown from the horse and injured. If the plaintiff had been reasonably careful, he could have observed the obstruction. If the plaintiff would have reasonably careful, he could have seen the obstruction from a distance of 100 yards and thus avoided the accident. It was held that the plaintiff had no cause of action as he himself could have avoided the accident. That is a contributor negligence. That is, Lord Ellen Borough, one person being in fault, will not dispense with another's using ordinary care for himself. Two things must occur to support this action. This is his contributor negligence. So here, this rule was this is a great hardship, particularly for the plaintiff, because for a slight negligence on his part, he may lose his action against a defendant, whose negligence may have been the main cause of damage to the plaintiff. The courts modified the law relating to contributor negligence by introducing the so-called last opportunity or last chance. So in most of the cases, contributor negligence disentitled the plaintiff to get damages, but the latter of this law was modified because with a observation last opportunity or last chance. Who was last opportunity means what? What is last opportunity? This law regarding contribution negligence has been modified subsequently by courts. What is last opportunity? Whose act would have prevented? If that is last opportunity, according to this rule, when two persons are negligent, what is last opportunity rule? Two persons are negligent. That one of them who had the latter opportunity of avoiding the accident. Two persons are negligent, one of which had the latter opportunity to avoid the accident by taking ordinary care should be liable for the loss. Now, that's because there is a contributor negligence that will not disentitle a person from claiming damages under the law. Now the law has been modified. Last opportunity rule. What is last opportunity rule? According to this last opportunity rule, when two persons are negligent, but one of them who had the latter opportunity of avoiding the accident, one of them who had the last opportunity to avoid the accident by taking ordinary care, if he doesn't care, then he should be liable for the loss. It means that if the defendant is negligent and the plaintiff having a latter opportunity to avoid the consequence of the negligence of the defendant does not negligent latter opportunity to avoid the consequence of the negligence of the defendant does not observe ordinary care, he cannot make the defendant liable for the act. Suppose defendant is negligent, plaintiff is negligent, both are negligent. That is control. But who had the last opportunity to avoid the accident, to avoiding the accident? If he by taking ordinary care, if he did not take that ordinary care, then he is to be blamed. What is that? In this case of Davis versus Mann explained the rule. In that case, the plaintiff fettered the forefeet of his donkey, tied the forefeet of the donkey, and left it on a narrow highway. Plaintiff tied the forefeet of his donkey and left it on a narrow highway. The defendant was driving his wagon driven by horses too fast that he negligently ran over and killed the donkey. The defendant that the donkey was standing, the forefeet of the donkey were tied, were fettered, so the donkey was unable to move, unable to go swiftly. Then the plaintiff, what happened? Brought his wagon, driving his wagon, driven by horses too fast, hastily, negligently ran over and killed the donkey. So, in spite of his own negligence, the plaintiff was entitled to recover because the defendant had the last opportunity to avoid the accident. If that were not so, said Parkway, a man might, what is case, the defendant was driving his wagon, driven by his horse too fast, that negligently ran over and killed the donkey. So, in spite of his own negligence, though plaintiff was negligent because he had fettered the forefeet of the donkey and left that donkey on a narrow highway, the plaintiff, that means here in the defendant, drove his wagon by horses and killed the donkey. So here in such case, so when plaintiff claimed damages for the killing of his donkey, the defendant pleaded that there was contributor negligence, but it was not sustained. It was the claim of the defendant because the defendant had the last opportunity to avoid the accident. He was not careful. If that were not so, said Parker B, a man might justify the driving over goods left on a public highway or even over a man lying asleep if this will not be followed. Suppose a person is sleeping on the by the side of the highway. Suppose they drop this, ran over that on that man. So they are contributing because he had the last opportunity to avoid the accident. So this is for that the defendant is liable. The above stated case was approved by the House of Lords in Radley versus L&M WR Railway Company. There the plaintiff were the colliery proprietors and they also owned a bridge near the siding from under which truck loaded with coal used to be taken by the defendants. One day the plaintiff loaded a truck so high that the same was obstructed by the bridge. Without trying to see what caused the obstruction, the defendant's servant gave momentum to the engine and also got the overloaded truck pushed by many other trucks on the defendants to make the truck pass under the bridge. The result was that the plaintiff bridge was knocked down. So here, in spite of negligence on the part of the plaintiff in overloading the truck, they were entitled to recover from the defendants because by an ordinary care, the defendants would have averted the mischief. So this last opportunity. What is last opportunity? Who had the last opportunity to avoid the accident? Both are negligent. Who had the last opportunity to avoid the accident? He should be blamed for the accident. He should be liable for the same. So in this British Columbia Electric Company versus Lords, the party who could have the last opportunity to avoid the accident, if you are not in negligence, was considered to be responsible for the accident. The party who had the last opportunity to avoid the accident, if it failed to take care, then he is to blame. In that case, the driver of a wagon in which the deceased was seated negligently brought the wagon on the level crossing of the defendant's tram line without trying to see whether any tram was coming on the line. That on the tram line, the driver of the negligently brought its wagon. So a train which was being driven too fast caused the collision. It was found that the train which caused the accident was allowed to go on the line with defective brakes because there were, and if the brakes were in order, then in spite of the negligence on the part of the wagon's driver, the tram could have been stopped and the accident averted. So here, because there was the brake was defective, this tram driver was to be blamed. So the personal representatives of the deceased brought an action against the tramway company. The defendant pleaded that the defendant himself took the wagon on the tram line. It was held that they could not take the defense of contributor negligence because they are the last opportunity. You very careful. The defense of contributor negligence cannot be taken in a tort if the defendant had the last opportunity to avoid the accident. So this is the rule, last opportunity rule. The rule of last opportunity was also very unsuspected because the party whose act of negligence was earlier altogether escaped. As a person is negligent, but if the other party had the last opportunity to avoid the accident with ordinary care, then he is to blame. Although he escaped the responsibility and whose negligence was subsequent was made whole liable. Past negligence was thereby that he avoided his act was excused, but the subsequent negligence of another makes the person liable. Whether this doctrine is applicable in India. In India, there is no central legislature corresponding to the law reforms contributor negligence act 1945. In England, there is a law reform that is contributor negligence act 1945. But in India, there is no such law. The position brought about by the law reform in England is very just and equitable. In Kerala legislature, there is a legislature has taken a lead by passing a Kerala Torts Misprisions Provision Act 1976. In Kerala, there is one act, that is Kerala Torts Miscellaneous Provisions Act 1976. What section 80 of the act makes provision for apportionment of liability in case of tumble. It is a very sound rule that when there is contributor negligence, the liability will be proportionally reduced, proportionally adjusted. That is apportionment. In various cases which have come before various high courts in India, the doctrine of apportionment of damage on the line of Law Reforms Act has been followed. So in most of the cases in India, before high courts, while there is a contributor negligence, there is a apportionment. Apportionment means this bearing of the damages by both the persons. In rural transport service versus Belgium BB, in this what is this? This is very important case. What is that? The conductor of an overloaded bus invited passenger to, always remember this. This on the roof of the bus, the driver swerved in the bus to the right, overtake a cart, and the driver turned the bus to the right, kacha portion of the road. Tahir Sheikh, who was traveling on the roof, was hit by the branch of the tree. He fell down and got serious injury, and later he died due to that. In an action by the mother of the deceased to claim compensation, it was held by the Calcutta High Court, that is, Rural Transport Service versus Belgium BB. In this case, Calcutta High Court, that there was negligence on the part of the conductor and the driver of the bus, and there was also contributor negligence on the part of the passenger who died. So the compensation payable by the defendant was reduced by 50%. That is, apportionment takes place. The compensation payable by this defendant was reduced by 50%, and they were to pay to this 8,000 instead of 16,000. In Subhakar versus Mysore State Road Transport Corporation, the court reduced the compensation payable to the extent the claimant was himself at fault. So in many various cases, this high courts in India, they have reduced the amount, apportionate the compensation amount when there is a contributor negligence. So there the claimant appellant who was going on a cycle suddenly turned to the right side of the road. He was hit by the respondent bus, resulting in his fall and injury to his leg, necessitating hospitalization for about 2.5 months. It was held that both the parties had equal contributor negligence, contributed to the accident by their negligence, and therefore the compensation paid to the claimant was reduced by 50%. Same rule was also followed in Vidya Devi versus MP Road Transport Corporation. A motorcyclist driving negligently dashed against a bus and died in the accident. The driver of the bus was also found to be negligent in the not keeping a good look so as to avoid a possible collision. It was held that between the deceased motorcyclist and the driver of the bus, the blame was in the proportionate of 2/3 and 1/3. That was also reduced. This is the rule. That is, in case of contributor negligence, the compensation amount is reduced. Considering to what extent the plaintiff is to be blamed, what extent the plaintiff had contributed. In Maya Mukherjee versus Orissa Cooperative Insurance Society Company case, the Orissa High Court adopted the principle of apportionment of damage in accordance with the fault of the parties. In that case, a motorcyclist had died after an accident with the defendant's car. The ratio of responsibility as fixed by the court was 60% for the motorcyclist and 40% for the car driver. The damage to the motorcyclist was assessed at 75,000, but the heirs were granted compensation of only 40,000 of the loss of 30,000. Similarly, Gujarat High Court also followed the same principle apportionment of the damage amount in case of contributor negligence. What is case in Rehana versus Ahmedabad Municipal Transport Corporation? There the appellant, a cyclist, was hit by a respondent but was found to be fault to some extent 25% for the accident. So the compensation was reduced. Contributor cannot be pleaded in only motor vehicle accident. In motor vehicle case, when there is a permanent disability, this contributor negligence, there is a clear provision for paying compensation of a particular amount. In such case, no fault theory. In such case, contributor negligence cannot be pleaded. Rules to determine contributor. The Contributor Negligence Act prescribes the rule where there is contributor negligence on the part of the plaintiff, whether there is contributor negligence on the part determined by the following rule. That is, rule is there. So doctrine of alternative danger. There is also what is doctrine of alternative danger. Although the plaintiff is supposed to be careful in spite of the defendant's negligence, There may be certain circumstances when the plaintiff is justified in taking some risk. Suppose the defendant's act is such, the plaintiff is justified in taking some risk, where some damages or dangerous situation has created by the defendant. The plaintiff might become perplexed. Suppose because of the act of the defendant, the plaintiff may become perplexed or nervous, and thereby and dangerous situation created by the defendant. And to save his person or property, or sometimes to save a third party from such danger, he may take an alternative risk. The law therefore permits the plaintiff to encounter an alternative danger. Suppose defendant has done some act, but ultimately the plaintiff is required to take some risk to save him. If the course adopted by him results in some harm to himself, if in that course he results in harm to himself, his action against the defendant will not fail. The judgment of the plaintiff should not, however, be rash. The position can be explained by the case of Jones versus Boyce. In that case, the plaintiff was a passenger in the defendant's coach. Plaintiff was a passenger in the defendant's coach, and the coach was driven so negligently that the plaintiff was alarmed. The coach was driven in such a negligent manner. The plaintiff was alarmed. He jumped so he jumped off coach and broke his leg. In this case, plaintiff had remained in his seat, he would not have suffered. If he would not have jumped from the coach, he would not have suffered any damage. It was held that the plaintiff had acted reasonably under the circumstances. So in such case, to enable the plaintiff to sustain in the action, it is not necessary that he should have the throne of the coach. It is sufficient if he was placed by the misconduct of the victim. Because of misconduct of the defendant, if he was placed in such a situation that is obliged him to adopt or to take an alternative dangerous leap to the remain safe. In Shamsundar versus State of Rajasthan, it is there that in this case, due to negligence on the part of the defendant, the state of Rajasthan, a truck belonging to them caught fire hardly after it had covered a distance of only 4 miles on a particular day. One of the occupants, Navnitalal, jumped out of save himself from the fire. He struck against a stone lying by the roadside and died instantly. The defendants were held liable for this. You cannot say that the plaintiff himself took the danger. He accepted the danger. Similarly, was the decision in Sayers versus Harlow Urban District Council. The plaintiff had paid for admission entered into a public laboratory provided and maintained by the defendant. The door has automatically locked and the lock was defective insofar as there was no handle inside to open the same. For about 10 to 15 minutes, she banged on the door and shouted to attract the attention of the person outside, but no came. And then, with a view to find a way to climb out, she placed one foot on the seat of the water closet and the other on the toilet hole. From there, she slipped and was injured. It may be noted that the defendant had given no warning of the defective lock and there was no attendant outside the laboratory. It was held that the defendants were liable. This is though plaintiff had himself taken the risk in certain situations. This is continued negligence of children. Suppose sometimes presumption that others. What is that? When what amount of continued negligence in the case of a mature person may not be same in the case of a child, because a child cannot be expected to be careful as a grown-up person. Age of a person therefore has to be taken into account to ascertain whether a person guilty of contributory negligence or not. So similarly, presumption that others are careful. There are many circumstances when the plaintiff can take for granted that the defendant will be careful. This is, in such case, he has no duty to guard against the negligence of the defendant. So in this case, what is that? In G versus Metropolitan Railway, the plaintiff, a passenger in the defendant's railway, lightly leaned against the door of a carriage not long after the trains had left the station. The door had been negligently left unfastened by the defendant's servants, and the same flew open, with the result that the passenger fell on the train. The plaintiff was entitled to recover even though he did not check and the door had been properly fastened, because presumption that the defendant is careful in certain situations. So this is the defense of contributor negligence can be taken only when the plaintiff himself has been negligent, but also when there is negligence on the part of the plaintiff servant or agent. So what is it? The defense of contributor negligence can be taken not only when the plaintiff himself is negligent, but also when his servant or agent are also negligent, provided the master himself would have been liable for such negligence. If the master is liable, if due to act of the negligent act of the plaintiff servant or agent, that is there is a contributor is to be blamed. The question is, can such a defense be pleaded for the negligence of an independent contractor? Independent contractor is something that is, he is not employing somebody. Supposing I hire a taxi and due to negligence of the defendant and also my taxi driver, there is an accident. Then, by which I am injured, can the negligence of the taxi driver pleaded as a defense for an action brought by me against the defendant? At one time, it was considered that in such case the plaintiff identified himself with such an independent contractor, and negligence on the independent contractor could be pleaded as a defense. So this is children, that is in custody of adults. Similarly, the doctrine of identification was at one time applied in case of children in charge of an adult, and such. If a child was incapable of taking care of himself, was in the custody of some adult, and was injured due to the negligence of the defendant and also the adult in whole custody, in whose custody he was, he could be made with the defense of contributor negligence as he was identified with the adult having his custody. So this is composite negligence when due to act of negligence act of both. This is called, they are joint tortfeasors. In case of joint tortfeasors, it is composite negligence. Two persons have committed a tort, they are called joint tortfeasors. When the negligence of two or more persons result in the same damage, they are proved to be composite. There is composite negligence, and the persons responsible for causing such damage known as composite tortfeasors. They are called composite tortfeasors. In England, such tortfeasors could be classified into two categories, that is joint tortfeasors and independent tortfeasors. And there were different rules governing the liability of the two categories of tortfeasors, independent or joint tortfeasors. The liability of these two categories of persons has been made somewhat similar through legislation, by legislation. But the court in India have not necessarily followed the English law, and they have adopted the rule which are in consonance with justice, equity, and good conscience. According to Indian conditions, unlike in England, the distinction between joint tortfeasors and independent tortfeasors is not of much relevance in India. Because the rule in India being different, the questions such as distinct has seldom arisen. For this reason, the term composite negligence has been used to cover cases where there are of negligence by joint tortfeasors, two joint tortfeasors or independent tortfeasors. So in case of joint tortfeasor and independent tortfeasor have different connotation. The term composite or joint tortfeasor, who joint tortfeasor means two persons are jointly liable. Independent tortfeasor has been used by that is in various cases in India. Certain kinds of problems in case of composite negligence have arisen, which have not been already, that is we say that will be treated as joint. Nature of liability in case of composite negligence, the liability of composite is joint and several. Only in India, when there is a joint tortfeasors liability, they are joint and several. One of them, that means the plaintiff may sue either both of them or in one of them. That is called joint tortfeasor, that is joint and several. And one of the tortfeasors is allowed to say that there should be apportionment. So, but the other side is that, and his liability should be limited to the extent of his liability. The judgment against the composite tortfeasor is for a single sum without any apportionment in accordance with the fault of various tortfeasors, and the plaintiff can enforce the whole of the claim against any one of the defendants. In case of joint tortfeasors, this liability can be enforced either jointly or severally, if he so chooses. The defendant who has paid more than his share of liability make a contribution from the other side. So in such case, the defendant who paid the damages, he can realize from the other joint tortfeasor his share of this liability from the other defendant. That is joint tortfeasor. This is called joint tortfeasor. That there could be apportionment by liability between the various tortfeasors, but that decision has been dissented in many subsequent cases. In the High Court of Madhya Pradesh, Madras, Mysore, many High Courts have expressed in favor of non-appointment of damage, non-apportionment, that is between various compositor work, with a discussion to the plaintiff. The plaintiff has a discretion either to against both the tortfeasors or against jointly and severally. This is in consonance with the joint and several liability. In case of joint tortfeasors, you should remember that they are jointly and severally. So two passengers buses brushed each other in such a way that the left hands of two passengers traveling in one of the bus were cut off below the shoulders. It was held that the present case was clearly cases of composite negligence, hence both the drivers are jointly and severally liable. Jointly and several. What is jointly and severally liable? That means the plaintiff has the option either to realize damages from both them jointly or from any of them severally. Then if one of the tortfeasor pays the damages, he can realize, he can sue the other tortfeasor to get his share of, to get back the amount for which he had paid, his share of liability. In Hiradevi versus Baba Kantidas, due to negligence of the driver of a state transport bus and the driver of a car, which were coming from the opposite direction, there was an accident resulting in death of a person traveling in the car and injury to some other person. The tribunal had made an apportionment. In the tribunal apportionment, the Guwahati High Court, however, held that the tribunal was in error in apportioning damage. Suppose the tribunal, the accident, motor accident claim tribunal cannot apportion it. This is a case of joint tortfeasor. So you should be very careful. What is joint tortfeasor? When two or more persons, they are liable under the tort, they are called, because of their both acts, they are joint tortfeasor. In such case, this liability, their liability to the plaintiff is either jointly or several. In such case, the plaintiff has an option either to sue them jointly or any one. He may proceed against any one of them. So Union of India of Higher General Insurance, the Rajasthan High Court held that there could be no apportionment of damage in cause of composite tortfeasors. In India, High Courts have held there should not be apportionment of damage. And observe that in such case, the claimant are entitled to damage jointly and severally. Jointly and severally, you should be careful from negligent respondent. In that event, it is no concern for the tribunal to, it is not the tribunal is not concerned to apportionate the damage. Only make them jointly liable and severally, jointly and severally liable. So in Pragya Datta versus Mahendra Singh case, there was an accident between a bus and a motorcycle, resulting in death of a pillion rider on the motorcycle. The bus driver and the motorcycle were equally negligent, and an action was brought for composite negligence against him. During the trial, the motorcyclist died and his legal representative were not implemented. It was held that in such case, the owner and the driver of the bus could be made liable only for their 50% share of liability. This is joint contributor negligence and composite negligence. You understand. In case of contributor negligence, the plaintiff has some amount of negligence in this last opportunity, who has the last opportunity to avoid the accident. That's it you have a case. In case of composite liability, they are called joint tortfeasor. In case of joint tortfeasor, their liability is both joint or separate. So plaintiff has, the tribunal cannot apportionate it, but the plaintiff has an option to proceed against both of them or against any of them. This is joint and several. Thank you.